Welcome to the Citizens Band Radio Hour. Thoughtful conversations that explore issues of media and journalism, democracy and citizenship. The Citizens Band Radio Hour is sponsored by the Center for Media and Citizenship at the University of Virginia. You can visit the center online at mediaandcitizenship.org. Here's your host, Coy Barefoot.
Burt Neuborne is a professor of civil liberties and the founding legal director of the Brennan Center for Justice at the New York University School of Law. For 45 years, he has been one of the nation's foremost civil liberties lawyers, serving as National Legal Director of the ACLU, Special Counsel for the now Legal Defense and Education Fund, and as a member of the New York City Human Rights Commission. He has argued numerous Supreme Court cases and has litigated literally hundreds of important constitutional cases in state and federal courts. Burt's book is Madison's Music on reading the First Amendment. This conversation was originally broadcast in the spring of 2015.
Every word, every idea in the First Amendment and in the Bill of Rights, all 10 of them, 45 words in the First Amendment, 462 words in the Bill of Rights, every single one of them is exactly where it's supposed to be because there's an underlying deep structure. You would never, for example, read a great poem and just read 3 or 4 words from one stanza and then move down to 3 or 4 words in another stanza, rearrange the stanzas, not care about the order. You would realize that that poem makes music, but it makes music because of the order of the words, of the structure is as important as the words themselves. It helps you understand the words. What I'm urging people to do is to read your Bill of Rights, read the First Amendment with the same intensity that you would read a poem, with the same respect that you would read a poem, and ask whether or not, when you read those words, all 45 of them, they don't tell you an important story that helps you understand what the words of the First Amendment actually mean. And so the thesis of the book is there's a deep and rich, deep structure underneath the Bill of Rights that Madison understood, and that his great music to us is the music of this wonderful poem. And we've lost the will and the ability to find it.
So let's start with that structure. Help us unpack that First Amendment for us,
Sure.
the order of the rights, the words, and then we'll talk about how the courts have torn it apart in an effort to preserve it.
Great. The First Amendment consists of 6 ideas. And we should recognize that this is the only time in our cultural history, going back all the way back to the Magna Carta, all the way up to the Bill of Rights and to today, that anyone has taken those 6 ideas and put them in the same text. Madison had 42 source documents that he was looking at when he was working on the Bill of Rights, ranging all the way back to the Magna Carta in 1215, to the English Bills of Rights, to the colonial charters, to the revolutionary state constitutions. Not one of them is organized the way Madison did it. So what he did is he said, look, 6 ideas. First idea is the Establishment Clause, no establishment of religion, which is essentially a protection against religion. It's freedom from religion. Nobody can use law to cram their religion down your throat.
It gets government out of the religion business altogether. It privatizes religious faith in America.
Exactly. You can't, if you're a religious person, you can't even hope to use the government to pound your religion into your neighbor. That's what it's for. It's to deregulate religion.
Right.
Religion is a private idea. Then there's the next clause, is the Free Exercise Clause. The Free Exercise Clause guarantees that you have the right to live out your religion, to live your beliefs and act your beliefs out in a free way. Now, when you put the two of them together, you realize what Madison is doing, and recognize this is the 18th century, that what Madison is doing is creating a free space for conscience. He's freeing up the interior conscience of a person, and that's where the First Amendment begins. It begins with freedom of conscience. Indeed, Madison wanted a third clause. He wanted a clause that would be a freedom of secular conscience, but he couldn't persuade the Senate to put it in. Eventually, the Supreme Court has put it in, so that you have protection of both religious and secular conscience at the beginning of the First Amendment. And that's where the First Amendment begins, in the free mind of a free citizen. It then moves directly to the third clause, which is the speech clause. Once you have an idea freely in your mind, then you want to articulate it. And so the free speech clause gives you the right to articulate it. But I'm going to reach more people on your show today than I could speak personally to in my whole life. And so Madison recognized that being able to speak personally about something isn't enough. You need some institution capable of transmitting the speech to a mass audience. And that's why the fourth clause is the press clause. The press clause comes right after the speech clause, because once you've spoken, then you need an institution that will transmit it to a mass audience. Once you've transmitted an idea to a mass audience, the next thing that happens in a functioning democracy is collective action in defense of the idea. And that's why the fifth clause in the First Amendment is freedom of assembly. It couldn't come before press because the mass dissemination of the idea hasn't happened yet. But once the mass dissemination of the idea happens, the assembly clause permits people to engage in collective action in support of the idea. And the amendment ends with the petition clause, the sixth clause, which says that once you've collectively organized around an idea, then you present it to the authorities, to the legislature or to the executive, and demand that they adopt it. And they have to vote up and down on whether to adopt it. So when you think about it for a moment and take a step back and read all 45 words, all six clauses, in the order in which Madison placed them, what you have is a blueprint for a functioning democracy. Indeed, I believe that the First Amendment is the story, is a poem about the functioning of democracy. It is the life cycle of a democratic idea that begins in a free citizen's free conscience, that is articulated freely, that is disseminated to a mass audience through the press, that is collectively organized on through assembly, and that is eventually through petition presented to the legislature for adoption. You couldn't get a more careful and a more perfect story of how democracy operates.
And then, of course, the 10th Amendment, which bookends this story, pulls the camera way back and says it infers all of these rights that may not be articulated in this document. They will be reserved to the people. And
for the people. Well, yeah. Madison's 9th and 10th Amendments do exactly that. I believe that that the reading that I just suggested to you, the reading of the First Amendment, which I call a democracy-friendly reading of the First Amendment, a democracy-friendly reading of the First Amendment would never tolerate a Supreme Court precedent that says the democracy is essentially owned by the rich. It would never say that money equals speech. It would never say that there's no way to control the effect of big money on politics. It would never say that people could be denied the right to vote because they don't happen to have an identity card in a situation where it's harder to get it for the poor in a context in which there's just no history of fraud. It would never say that partisan gerrymandering is okay, that you can just draw lines where you know in advance who's going to win and help the party in power and hurt the party out of power. A Supreme Court that recognized that it had a First Amendment that was democracy's best friend would understand that they should interpret the First Amendment to help democracy work as well as it can and should. And instead, the current Supreme Court uses the First Amendment as democracy's bad parent. It essentially says that the First Amendment disciplines democracy, makes it impossible for democracy to deal with big money, makes it impossible for democracy to deal with partisan gerrymandering, makes it impossible for democracy to deal with cynical attempts to disenfranchise the weak and the poor. And that, to me, is exactly the opposite of the way they should be reading the First Amendment. And it's in large part because we've lost the ability to see the whole amendment. ability to see all 45 words. Because what we wind up doing, and we have now for a very long time, is instead of trying to read the whole amendment the way I wish we would, we pull words out of it. We pull a couple of words out of it. For example, we'll pull the free speech clause out. The free speech clause says Congress shall make no law abridging the freedom of speech. Well, we can't read that literally because we want it to mean more than Congress. And we want it to cover more than laws. We want it to cover regulation. We want it to cover the cop on the beat. And we don't even try to figure out what the freedom of means. So we throw those three words away. So then we have the Supreme Court saying, it says Congress shall make no law abridging speech. Now, by and large, that's a pretty good idea. But it doesn't solve everything. And then when they turn around and use that to say money equals speech, and therefore there's no way you can control money, what they've wound up doing is mugging the very democracy they're supposed to protect. It's all because they don't see the way all six of those clauses fit together in this beautiful story about the functioning of democracy.
They've cherry-picked it as if each of these clauses was a separate amendment, and there's a reason, if I understand you right, Burt, there's a reason that Madison wrote this all as one amendment and not six separate amendments.
Sure. He could have written six amendments. He could have put the. In fact, he thought about doing it that way, and was finally persuaded to list everything in a single amendment. He could have done all sorts of things that would have justified reading things in what I call a fragmentary way, but he didn't. What comes down to us, this enormous gift that comes down to us, is the same thing as if some poet were to have written this wonderful poem in the 18th century, and instead of reading the poem, we insisted on tearing it apart and reading just a couple of words and reading a couple of stanzas. And we couldn't understand why anybody would think that guy was a great poet, because we're looking at the words and the stanzas, and they don't mean all that much. That's what we do with Madison. If we read Madison's handiwork with the same intensity and the same respect that we read poetry, we would revolutionize the way we read the First Amendment. The First Amendment then could no longer be read as this kind of isolated, deracinated set of words that winds up biting democracy instead of protecting it. And you can do the same thing with the whole Bill of Rights. All 462 words, all 10 amendments of the Bill of Rights are organized in the same brilliant way, like nothing else in any document that I know of. Madison starts with the First Amendment because that's the most important thing they were trying to do, create this new idea of a tolerant, egalitarian democracy that would where people could rule themselves. And then he says to himself, and the founders say to themselves, what are the risks to the democracy? What's going to happen to this idea when we launch it? And the very first thing they say is military overthrow. That military overthrow is the greatest danger to the kind of democracy that they were trying to create. And in fact, they were right. More than 90% of all the democracies that have ever been attempted in the world have essentially fallen prey to their military. Either their military or their police have essentially taken over the government. And so what Madison says is, how can I fix that? I know that that's the most dangerous thing, so I want to fix it. So he puts in a Second Amendment. The Second Amendment is second, not because that happens to be where the ink on the wall was splattered when they threw the pot of ink. It's second because it is the most dangerous risk to the first. It's designed to control the first, to control the risk of military overthrow to the first. And what Madison does brilliantly is he says, look, the real danger is that the standing army, the army, doesn't look like the people. It's different than the people. The social classes that make up the standing army don't represent the polity that the army is designed to protect. And eventually that means that the army is a real risk of turning on the polity that it doesn't look like. And so what Madison does is he creates this well-regulated militia, which is the people in arms, everybody. It's the shadow army of the people. And they're all there in arms in case the standing army turns on the democracy. The people are there armed to protect the democracy. And it's a brilliant institutional stroke. And again, what the Supreme Court has done is instead of reading the Second Amendment as an understanding that the reason that it's second is because it's designed to protect the first, they read it as though it were a completely freestanding amendment, and they tear out from the Second Amendment all the language about the well-regulated militia, saying, well, that's just a preamble, we can ignore that. And so you're left with a text fragment that gives people the right to go off in the woods and have guns, but has nothing to do with the fundamental protection of democracy, which the Second Amendment was all about. Because Madison understood in 18th century Virginia, just like 21st century Ferguson, Missouri, that if you have an armed force that doesn't look like the people it's policing or serving, that armed force is going to turn on the segments of the people who are not represented in it. And the modern reading of the Second Amendment, the best reading of the Second Amendment today, is that it guarantees everybody the right to serve in the organs of armed coercion. Gays can serve in the military. Women can serve in the military. Blacks can serve in the military. Gays can serve in the police force, women in the police force, Muslims in the police force, so that the organs of armed coercion will look just like the people and therefore not be a great risk to turn on them. And then the Fourth through the Eighth Amendments is a perfect recapitulation of the criminal justice system, which Madison saw as the second great threat, the enforcement of the criminal law, as the second great threat to the First Amendment. The Fourth through Eighth Amendments are a perfect chronological recapitulation of the criminal justice system, the criminal enforcement system. The Fourth Amendment deals with investigation and arrest. The Fifth Amendment deals with interrogation. The Sixth Amendment deals with criminal adjudication. The Seventh Amendment deals with civil adjudication. And the Eighth Amendment deals with punishment. Now, you couldn't get it any better way. And if we only read it that way, if we only read the amendments that way, in that kind of order, we would realize there's no white spaces in there for the government to hide. The government can't run a surveillance program on the grounds that, we're in between the Fourth and Fifth, and therefore there's a white space there and a constitutional opening for us to do anything we want. If we read the Fourth through the Eighth Amendments the way we should, as a coherent whole, we would find out that we had a coherent and completely effective set of protections against government overreaching in the criminal justice system. And then, as you point out, the Ninth and Tenth Amendments are perfect, a perfect way to end the Bill of Rights. He ends the Bill of Rights by telling us how we should read it. And he says, look, I'm not perfect. I might have left some rights out. And so the Ninth Amendment says those rights still exist, and the people have them, and if in the future it's necessary to recognize them, go ahead and do it. If we need more rights, go ahead and find them. And the Tenth Amendment says, but I'm pretty sure I got all the powers down. And so I don't want to give government any more power than I've already given it. So you can't find new powers, even though you can find new rights. If you think about that for a moment, the intersection of the Ninth and Tenth, a command to read rights broadly and powers narrowly, that's how you keep a people free. And in 1958, Justice Harlan on the Supreme Court applied that. What he did is he said, look, there's a seventh non-textual right that I want to add to the First Amendment. There are these six textual rights, establishment, free exercise, free speech, free press, assembly, and petition, but I'm going to add a seventh. And the seventh thing I'm going to drop in there is freedom of association. The word association doesn't appear in the First Amendment. Harlan essentially created it, and he created it because he was doing just what Madison wanted him to do. Under the Ninth Amendment, he realized that there was another right that was necessary to make the first work better as a protector of democracy. And so he drops freedom of association in there so that we can associate intellectually without having to assemble physically. And he completes the First Amendment that way by adding a non-textual right. And it just shows the brilliant way the text should operate if only the justices are reading it as a single organic whole.
We're talking with Burt Neuborne of the NYU School of Law. His book is Madison's Music on Reading the First Amendment. And Burt, the Third Amendment, in a really beautiful way, connects the Second and the Fourth. The use
exactly.
Of,
Good for you. Yeah, exactly. The Third Amendment is the one that says that you can't quarter troops, and it is an attempt at protecting us against military occupation in our homes. And, of course, the Fourth Amendment protects us against law enforcement searches in our homes. So it just shows how beautifully organized the text is. You will not find a Supreme Court case in the last 50 years in which they attempt to read it as a coherent whole. They've just lost the habit. They would read the Third Amendment if a Third Amendment case came up by just tearing the Third Amendment out, holding it by itself, and thinking that they could get the meaning without understanding how it fits into the larger picture of the entire First Amendment and the entire Bill of Rights.
Let me ask you about an item in the headlines recently, and that's the legislation adopted in Indiana. And there is similar legislation around the country, even here in Virginia, that grants, on religious freedom grounds, it grants the right to discriminate against clients, customers, people who come to your shop or your business or your bakery. What crosses your mind when you read about this kind of legislation and what's going on in Indiana?
Well, there are two things that cross my mind. First of all, I wonder if the proponents of the legislation realize what the net effect is going to be. If there's no statute compelling people to serve gays, for example, existing law says that they can not do it. You don't need a special statute to protect them. The federal statute that was passed in the 60s protects against race, discrimination on race, gender, religion, and national origin. It does not cover gays. 21 states and the District of Columbia cover gays, but most of the states of the United States, including Arkansas and including Indiana, where you have these statutes, don't. So the thing that puzzles me is why they're passing a statute to give you a right to do something that you already have the right to do. And ironically, in Indiana and Arkansas, the net effect has been that they had to add a clause saying, however, this does not authorize discrimination against gays. So ironically, and I think involuntarily, they didn't even realize it, Indiana and Arkansas now join the 21 other states that have protected gays against discrimination by places of public accommodation. And I actually said, boy, that's a great strategy for advancing the rights of gays. I would never have thought of it. So congratulations to the governors of both states for thinking of that. And then the final thing, the extraordinary thing, is it doesn't even get them what they think they're going to get, because they have fallen prey to exactly what I'm concerned about. What they're doing is they're reading only the free exercise clause of the First Amendment. They say, well, the First Amendment has a free exercise clause, so of course we can pass statutes that permit people to exercise their religious rights. And they forget that that's the second clause, that there's a first clause. And the first clause in the First Amendment is the Establishment Clause that says that you can't pass laws forcing third persons to bear the costs of your religious beliefs. So, for example, if you pass a statute saying that you have to give, let's say, a store, that everybody that works in the store has to be given their religious day off on the weekend, so that the people who worship on Sundays have to be given Sundays off, Sabbatarians have to be given Saturdays off. That law, sure, it helps people exercise their freedom, but what it also does is it requires everybody else in that workforce to work on the weekends. It's because if they don't have that same kinds of religious belief, who do you think is going to get stuck working on the weekend? It's the rest of the workforce. And the Supreme Court held that exactly that statute in Connecticut was unconstitutional because it shifted the costs of the free exercise of religion by the workers that wanted to take Saturday and Sunday off. It shifted that cost to the other workers in the unit. And that's an Establishment Clause violation. Well, if what you do is you tell a photographer or a florist or someone like that they don't have to serve gays if they don't want to, then what you're on religious grounds, on the ground of what you've done is you have enabled the florist to exercise his free exercise rights, but you have done so by passing a law that shifts the cost of the exercise to the gay customer. And that's exactly what the Establishment Clause says you can't do. So when you're going to think about what you can do here, you can't just look at the Free Exercise Clause. You have to look at both. And the Supreme Court was very careful in that famous Hobby Lobby case a year ago, where they gave employers a religious exemption. Justice Alito, in writing for the court, was very careful to say there's a zero cost here. We are not shifting the cost to anybody because the employees will continue to get the identical coverage because the insurance company is willing to provide it for nothing. He knew that if there was a cost, there would be an Establishment Clause problem. And that is exactly what's happening in these states. The states are first passing statutes that improve the legal rights of gays, and they're passing the statutes that won't even achieve the end that they want, because when they try to apply them, they're going to be found that they struck down as Establishment Clause.
On those same grounds, couldn't we bring into question the government's state, local, and federal government's tax-exempt status for religious faiths, because they're using a religious freedom grounds to pass the costs on to other people who don't benefit from that tax-exempt status?
Well, good for you. That very same argument was made in the early 1960s to challenge tax-exempt status of churches on the grounds that it shifted costs. And what the court found was that in order to qualify for the exemption, you had to be the type of institution that was prepared to give services free to large numbers of people. And so they found that what the churches and other charitable institutions that were tax exempt, that what they were doing was providing a free service to the community that was functionally the equivalent of what the tax would have been, and therefore they were not shifting the costs to the community because they were providing other forms of benefit. And a number of people thought that was about as far as you could go and still protect the Establishment Clause. But the court realized that if they admitted that they were shifting costs, that it would violate the Establishment Clause.
Right. Burt Neuborne is the author of Madison's Music on Reading the First Amendment. Burt, would you take a moment and share your thoughts about what are the key takeaways from the actions of Edward Snowden, and how do you believe that Americans should make sense of what he has done, the legacy of his actions, and what we have learned about the surveillance programs that the federal government is currently engaged in? As I like to tell my listeners, every day somebody gets up and goes to work in Washington and violates the U.S. Constitution. And as far as I'm concerned, they should be in jail, but they have great jobs.
You raise a really complicated and a very, very hard issue, in large part because we won't read the Fourth through the Eighth Amendments as a coherent whole. We've tolerated the growth of a surveillance state where the United States gathers vast amounts of information on all of us, stores them, and I'm sure they use the information, they hope to use the information for good cause, but it winds up, of course, eliminating any notion of privacy that we have in this society. I mean, we live in what I call a naked society, where the government has the ability to get information about you and then to use it secretly. And to do things that we just never know. It's like trying to run a democracy in the dark. So the first step is to try to see if we can recapture the idea of constitutional limits on the government's ability to obtain information about ourselves. It's not impossible to do. European societies do it very well. We could do the same thing here if we committed ourselves to a serious set of protections against government surveillance. So Snowden, confronted with that, essentially decided to take the law into his own hands. I mean, he's working, seeing the violations of the Constitution happening right in front of him, watching this information be used, and he fundamentally, I think, lost faith in the ability to fix the system from in the standard way we do it, and instead decided he would unilaterally take the law into his own hands and make all the stuff public. Now, you can argue that he did us a great service, because otherwise we would never have known what was going on. But you can also argue, and I'm troubled by the fact, that unless we can at least enforce some notion of secrecy in what we do, that, for example, we would never have been able to conduct negotiations with Iran if those negotiations were on the front page of the New York Times every single day. So there has to be some ability to keep secrets. And what Snowden has done is to tell us that we are so far on the wrong side of the line. We're gathering so much information and keeping so many secrets that we must reform our system if we want to keep the democracy that we have. On the other hand, having taken the law into his own hands, it's possible that he's going to have to suffer a legal consequence for it. Not the kind of consequences that people are talking about, like life imprisonment or horrible stuff, but like anybody who engages in civil disobedience, there is the possibility that some sanction should be, a reasonable sanction, should be taken against you.
What do you make of the current president's use of the Espionage Act? Has gone after more government whistleblowers under that law than all previous presidents combined. How are we to understand that?
Very troubling. Very troubling. One of the central issues that we're going to have to deal with as a people is the slow growth of a presidential state where presidential power risks overwhelming everything else. Part of it is the dysfunctional nature of Congress. If Congress started behaving the way responsible people should behave when they attempt to govern a great nation, they wouldn't be creating these huge power vacuums into which the president steps. If we really had governance by all three branches, then we wouldn't necessarily be looking at the rise of an imperial presidency. But we don't have that, unfortunately, and I don't see any prospect in the reasonable future where we are going to get a functioning Congress. And that just encourages the president to take more and more and more action, one, because he believes in it and thinks that it can't happen any other way, and two, because he can, because nobody fights back, because nobody is pushing back in the other direction. And so my sense is that if we're serious about separation of powers, which is another one of Madison's very important ideas, Madison tried to put the separation of powers clause into the Bill of Rights, and they took it out. But he understood that the enforcement of the separation of powers was very, very important. And I think the president's use of the incredibly ambiguous language in the Espionage Act to go after press, to go after the reporters who were just doing their job, is a great mistake, and it's a disappointment.
When scholars like yourself and historians read the letters and the writings of Madison, it's amazing how the red light starts to flash and you realize, oh my gosh, he's writing about the 21st century. He's writing about Obama. He's writing about Bush. He understood, and Jefferson with him. They were terrific students of history, and they understood they understood the threats that existed that would always be at the door knocking to corrupt the government that they had helped to create. And they were so prescient.
Exactly right. Well, don't forget, they were writing at the Big Bang. They were writing at the moment that democracy exploded as an idea into our consciousness. So they were highly conscious of what it would take to run a society that was self-governing, and they were highly conscious of the risks. And because they were so smart, it shouldn't come as a surprise that these guys, thinking at the very beginning, at the inception of the idea of democracy as being a serious idea in Western culture at the end of the 18th century, it shouldn't surprise us that they had insights about the way democracy should work and the risks to democracy that are relevant today. Because they haven't changed. Democracy itself as an idea hasn't changed, and the risks to democracy itself haven't changed. It's one of the reasons I wrote the book. I wrote my book because I believe the First Amendment and the Bill of Rights shouldn't be left to lawyers. It's too important to leave to lawyers, too important to leave to judges, that the history of the First Amendment and the history of the Bill of Rights is that they eventually come to reflect the meaning that the people demand of them. When we moved from segregation to integration in Brown versus the Board of Education in 1954, it's not because the judges got smarter. It's not because the language changed. It's because the people demanded a society in which race wouldn't be used as a device to penalize the weak. It's the same thing with the First Amendment. We will get the First Amendment that we deserve as a people. And if we're willing to let the Supreme Court tear little pieces of it out and pretend that they're reading the whole text, then we're going to get a fragmented, dysfunctional First Amendment, and we're going to have to learn to live with it. But if instead we realize that those words tell a story, that there is a remarkable underlying structural coherence to the First Amendment and to the Bill of Rights, and if we start demanding a court system that recognizes that structural coherence, we'll have a much stronger Bill of Rights and a much, much more effective democracy.
Burt, before I let you go, I just want to get your thoughts. Over the last 3 decades, certainly, we have seen some chilling attacks against democracy in America. And you've been on the front line in many of those battles. What gives you hope in America today in 2015? What gives you hope that the principles in Madison's writing, that these ideas that were crafted into words in the 18th century, that the principles that they express will survive, and not only survive, but that we can do what every generation of Americans should do, and that is leave freedom stronger for those who come after us. What gives you hope that we can accomplish that?
Well, you can't do what I've done. I've practiced civil rights law now for 50 years. You can't do what I've done without being something of a romantic, without believing that it is possible to roll the rock up the hill. It is possible to achieve in spite of the odds against it. And one reason why I am hopeful, I won't say confident, but one reason why I am hopeful that we can continue to govern ourselves as a self-governing society is that we've made enormous progress over the last 50 years. We shouldn't lose sight of the fact that when I started practicing law back in 1964, we were only 10 years away from segregation. And most schools were still segregated, most parks were still segregated, that we were a society that would not even confront our racism, much less try to do anything about it. Women were essentially subordinated. They had virtually they didn't serve on juries most of the time. They were radically underrepresented in every kind of powerful place. Gays, my goodness, you couldn't even think about gay rights. It was so totally off the wall. And I've lived through a society that for 55 years of peaceful evolution has started to confront its race problem and to try to think its way out of it, with many decent people on the left and the right trying to think their way out of it. I've seen an absolute revolution in the role of women in the society. It's one of the most revolutionary things that any of us could have seen in human history. And we've lived through it, and it was peaceful, it was disorienting, but it's remarkable to come out the other end of the tunnel and see a different society. I've seen us literally invent the idea of gay people as being our neighbors and our friends and our equals, when no one thought about that. I've seen us maintain a society in which, almost unmatched anywhere in the world, we have religious toleration. And not only do we have religious toleration, we have respect between and among the religions. They respect each other. They tolerate each other. I've seen us as a society have perhaps the most vibrant speech than any society has ever had. Now, I have my complaints about some of it, but when I see what we've done over the last 50 years as a free people, I have every reason to think that we will continue to be able to confront the problems, and if we act together as a free people, surmount them.
Burt Neuborne is one of the nation's foremost civil liberties lawyers. He served as the National Legal Director for the ACLU in the 1980s. He is the founding legal director of the Brennan Center for Justice and a professor of civil liberties at the New York University School of Law. His must-read new book is Madison's Music on Reading the First Amendment. Burt Neuborne, I am so thrilled that you had some time to join me today, and I just want you to know what a sincere personal honor this was for me and for all the listeners as well, I'm sure. Thank you for all the work that you have done and that you continue to do. It's a beautiful book.
Well, that's kind of you. Thanks very much. I enjoyed it.
You've been listening to the Citizens Band Radio Hour, a production of the Center for Media and Citizenship at the University of Virginia. Archived podcasts are available online at mediaandcitizenship.org. The executive producers for the program are Siva Vaidyanathan and Coy Barefoot.